Mr. Chairman, we're live.
Okay, thank you. So with that committee, we are live, streaming on YouTube, I guess. And with that, Diane, take the roll, please.
Representative Baker,
Here.
Representative Brown,
Here.
Representative Burt,
Here.
Representative Henderson,
Here.
Representative McGuire,
Here.
Representative Obermuller, Representative O'Hearn,
Here.
Representative Stivar, Chairman Burkhart.
Here. Okay. Just a reminder to everyone to follow the decorum we usually use in meetings. Please speak through the chair. I know we have a number of people who will testify virtually on this bill, and we'll take sorry, I have more papers here than I can keep track of right now. So we have Senate File 7, Senate File 4, and Senate File 107. And with that, we'll start with Senate File 7. And we have someone to present the bill. It was a committee bill. Director Reiner. Again. Director, you're muted.
Sorry about that, Mr. Chairman.
That's
So,
okay. Someday we'll fix this.
You'd think after a year of this, we'd have that figured out. So, hey, for the record, Luke Reiner, Director YDOT. Mr. Chairman, certainly Senate File 7 was an interim bill that was worked hard over the legislature. And I will turn over the briefing of the bill with your permission to Mr. Kirkmeyer. But let me just maybe set the stage. So autonomous vehicles are coming, and they're on America's roads today and in certain places. And what this bill does is it sets the left and right limits. It sets the legal framework for how we adopt and how we incorporate those vehicles onto our roads. We did have a robust stakeholder group that worked with us to help develop these rules. And with that, Mr. Chairman, let me kick it over to Mr. Kirkmeyer to talk to you a little bit about the interim process and then walk you through the bill.
Mr. Kirkmeyer, please proceed.
Thank you, Mr. Chairman. Just to give the committee a little background, we were directed to provide recommendations on a bill that could safely and efficiently integrate autonomous vehicles into Wyoming's transportation systems. We got some other guidance. It was to be holistic and to treat as much as possible vehicles with automated driving systems as every other vehicle on the roadway. And then finally, we were told to be not overly restrictive or regulatory. Part of that was consideration of making one bill. A lot of states split this into two. They have one bill that addresses testing and then a separate bill for integration of the vehicles into the system. And so we just provided our best recommendation on one bill. As the director said, we established a working group in February of 2020. Consists of members from the legislature, from the University of Wyoming, from the autonomous vehicle industry, Wyoming Trucking Association, the Wyoming Automobile Dealers Association, from the insurance industry, and of course, subject matter experts from YDOT, amongst some other folks. It includes both people in and outside of the state. We meet every other month to review things, and then we do have 3 subgroups that work specific issues and then brings them toward the main working group. As a result of the efforts of all these folks, and we have got about 24 total that we provided our initial recommendation to the Joint Transportation Committee. Just to give you a background in the timeline, as I stated, we established the working group in February 2020. In July of 2020, we briefed the Select Committee on Blockchain, Financial Technology, and Digital Innovation because at that time they were considering a testing-only bill. And we gave them kind of the background on the efforts and what we were doing. We then briefed the Joint Transportation, Highways, and Military Affairs Committee in September of 2020. And at that time, we told them that we thought we could provide a holistic bill recommendation to them by their November, December meeting. We did. We got together with the working group. We included the co-chairs at the time of both the JTC and the select committee on our efforts, and we presented that to LSO and those co-chairs in October. We reviewed the bill for the JTC at their December 2020 meeting, and what we have today, sir, is what's finished coming through the Senate. Pending any questions, sir, I'm ready to carry you through the bill.
Any questions at this point? So, Mr. Kirkmeyer, please take us through the bill.
All right, sir. Again, this is an automated driving system regulation bill. Many of you probably know it as autonomous vehicles. We did change the wording to automated driving system. I'll get into the reasoning of that later. We'll start right in and jump right in and go to definition, section 3121-101 on page 2. I would like to note that all the definitions in this bill are taken from the Society of Automotive Engineers Standard J3016, the June 2018 edition. And that was an effort to make sure that we use the same vernacular as being used in the industry and in other departments of transportation. So all the definitions in this bill are taken verbatim from that standard, except for the very first one, which is automated driving system data recorder. That definition, I believe, came from a different stakeholder. I will note for the committee that the term automated driving system data recorder is no longer used in the bill. It was in a previous edition. The department recommends that we actually eliminate this definition because it is no longer used. Pending any questions, I will continue on. The second thing also on page 2 I'd like to note is the definition of automated driving system. We did have some friction because some of the industry representatives only represent companies engaged in building level 4 or level 5 systems, but some of our stakeholders represent industry groups that build level 3 systems. In order to, yes, sir.
Would you please give us a quick definition or idea of what level 3, 4, and 5 are?
Yes, sir. Level 3 system is what you're starting to see almost come out from some of the manufacturers. It is highly automated. However, it does require the driver to be licensed and to monitor the system in some conditions or in most conditions. So this is beyond your cruise control or your blind spot warning. The vehicle can actually follow behind other vehicles, but it cannot do the entire driving tasks by itself. It does have to have some human input or some human correction. The next level is level 4. And in most conditions, a level 4 system will be able to operate on its own. However, again, this system requires some kind of human integration or human monitoring while it is engaged. And then a level 5 system is something that can completely drive on its own. In fact, you'll see some of these types of vehicles run as taxi services in large cities or on universities, and they may not even have a station for a human driver. The vehicle is capable of being engaged, and it typically drives a known route. So everything is programmed into it, but it does not require any human intervention.
Thank you.
Yes, sir.
Continue.
Yes, sir. Again, level 3 systems are typically being built by industry legacy manufacturers, the folks that have been around for a long time. 4 and 5 are your newer manufacturers. And because we were given the guidance to be holistic, we recommended that the SAE J3016 definition, which includes level 3, 4, and 5, be included, and that's why that definition is in the bill. Continuing on, sir, I don't think there's anything really to highlight in definitions until we get to page 6, on-demand autonomous vehicle network. As we get to this section in the bill, I'll highlight the friction point there. There was some discussion about whether or not to treat commercial and on-call vehicles like taxi services or transportation companies. The language that we will cover in the bill is what was decided. From the department's perspective, we don't have a recommendation on how the legislature chooses to qualify these companies that would engage in commercial operations with autonomous vehicles. The next one, sir, I will highlight again as we get into the bill, but is just below that, operational design domain. And that is an important caveat, because when we get to some of the things the vehicles are designed to do, it matters later on in the bill. But really the ODD, or operational design domain, for the vehicle is how the vehicle is programmed and designed to operate, and what things it can and cannot do. And I'll highlight those later on in the bill. I'll continue on unless there are any other questions about definitions. I will continue on to page 7 and go over section 3121, 102, operation of a vehicle equipped with an ADS without a human driver and safety at railroad crossings.
Please continue.
All right, sir. So, Mr. Chairman, here's what I wanted to highlight for you, the whole notion about operational design domain. Everything prior to this is pretty self-explanatory, and it does match what the department recommended. However, when we get to paragraph A, subparagraph V, small v, or subparagraph 5 on page 9, that is an addition. And that addition addresses railroad crossings. From the department's perspective, we did not recommend this addition. It came through in a later point. Not that it really matters much. However, that being said, when you look at the wording here, it directs that the vehicles be capable of operating within their operational design domain. And then it singles out safely negotiating railroad crossings, unless an exemption has been granted by the department. So first, a vehicle not capable of safely negotiating a railroad crossing wouldn't have it in its operational driving domain. Therefore, the vehicle would not attempt this on its own anyway. If it were out without a driver, then the vehicle would bypass these known obstacles. Secondary, considering an exemption, we really can't understand or determine why the department would want to exempt a vehicle not capable of negotiating a railroad crossing by itself anyway. Not to say that this paragraph isn't important, but it really doesn't add anything to the safety. In fact, it does call out a specific instance where a vehicle and its operational design domain are singled out, and it could open up opportunity for a bunch of other things to be included in here, like school zones or work zones or any other possible obstacle a vehicle could run into, but that is not in its operational design domain. So while this language isn't necessarily harmful, it's not specifically helpful to the department and really doesn't provide us any additional guidance that we wouldn't be able to get through, other than to note it could cause some folks to start listing specific items that they would want to be addressed in here, which really aren't necessary.
Okay. Any questions for Mr. Kirchmeier at this point? Mr. Kirchmeier, I do have one, and I'm in that paragraph Romanet 5, line 9. What is on-site diagnostic, if you know?
Sir, Mr. Chairman, I do not know. We did not recommend this language. And so I really don't know what the person who recommended this language was referring to. And again, this gets to the whole notion of why the department would want to grant an exemption to a vehicle to cross a railroad crossing if it wasn't built to be able to maneuver through that obstacle in the first place. I mean, there might be some really remote reason, but we really can't think of one.
Okay, thank you. Proceed.
Yes,
Oh.
Mr.
Representative Stiver.
Thank you, Mr. Chairman. The railroads, do you think it has something to do with the railroad crossings themselves, gated and ungated crossings?
Mr. Kirchmeier?
Mr. Chairman, I believe that assessment is correct in listening to the testimony during some of these previous meetings by the railroad representative. I suspect that's what they were after, and that makes sense to me. But again, when they use the term dynamic driving tasks, and within their in their operational domain, my best understanding, and again, I'm not an engineer and I'm not an attorney, but my best understanding is the vehicle, if it has not been designed to negotiate whether it's a gated or non-gated railroad crossing, that it wouldn't be in its operational domain, and therefore wouldn't attempt it. But I'm not an engineer and I'm not an attorney. I understand the intent behind the paragraph, and again, I don't think it's harmful to us. Other than I just wanted to note for you that once you start listing possible exceptions or possible things that could get in their way, you kind of open it up for a whole bunch of other things that could then come in and be put into a paragraph or later on put in to try to figure out where you can exempt them or not exempt them, especially when exempting them would probably cause a safety issue in the first place.
Other questions? Mr. Kirkmeyer, please proceed.
Sir, I will continue on to 21-103. I just want to highlight paragraph A, subparagraph 3. This was an important change to some of the original language. This is where we noted that level 5 vehicles are built to not require, and in some cases may not even have a station for a human driver. So what it does is it separates those vehicles out so that they are not required to have the person, the dispatching entity, basically the person that pushes the go button on the vehicle, be licensed to operate it. And that was important for a number of factors. The first one is this technology has the ability to do things for folks who are no longer mobile by themselves. So if someone has a disability or they're no longer capable of driving, if they own level 5 technology, they can send the vehicle on errands to pick up medicine, to pick up food, to pick up the kids, to pick up the dry cleaning, the types of things that you would want to use this technology for. So we recommend that this language in subparagraph 2 remain. Vehicles with 3 or 4 automation do require a driver licensed in that type of vehicle, but level 5 vehicles do not only because of the ability of the technology, but also because some may not even have driver stations. So the person, the dispatching entity, would never be able to become licensed in it in the first place. Pending any questions, I'll
Representative McGuire.
Mr. Chairman.
Thank you, Mr. Chairman. So taking that in the opposite direction, basically, why would we continue to require anybody who is physically operating a vehicle? How can we require them to continue to take all of the training and pass the CDL and exhibit their competence to operate that vehicle, where we're excluding somebody who nobody's ever met, may not even be in the state of Wyoming, may just be a shadow behind a keyboard, and you're suddenly extending an exemption to them? I simply don't understand. Could you help me with that, please?
Mr. Kirkmeyer?
Mr. Chairman, to answer the question, again, I think it's necessary to take the whole section in context. The section says that for the purposes of the vehicle, when the system is engaged, it is considered to be the licensed operator or driver of the vehicle. And then it gets further into the notion of the dispatching entity, which is the person that, or entity for that matter, that sends the vehicle on its way. In the cases of level 4 or 3 or 4 automated vehicles, they're not technologically capable of being dispatched without some sort of human interaction with the vehicle and the vehicle a person in the driving station at the same time. When you understand the whole description and context of what a level 4 or level 5 automation is. Both of those levels of automation require a human to at least monitor the vehicle's operation. So by nature of what level 3 or 4 automation is, it has to have a licensed driver in it. When we're talking about a level 5 vehicle, the technology is established in such a case as no human is required to manage the operation of the vehicle in its operational design domain. So basically the vehicle can do what it's required to do to safely do it. It's gotten this appropriate licenses and certifications from the federal government, and it can do that. It can operate within its driving design domain safely and effectively. Therefore, in order to dispatch the vehicle, which is different than operating the vehicle, there is no requirement for the dispatching entity to be licensed.
Okay. Other questions at this point? Okay, Mr. Kirkmeyer, please proceed.
Next section, sir, is 3121-104. It's on starts on page 10 and goes to page 11. Really, this is just to highlight how we are trying to treat these vehicles as much as possible like non-automated driving system vehicles. And this basically says the same insurance requirements are required for these versus non-automated driving vehicles. Continuing on, section 3121-105, duties and crashes involving vehicles.
Mr.
Here's where I will.
A question, please, on that one.
Yes, sir.
If this vehicle is, say, a class 5 vehicle and can be controlled from someone outside of Wyoming and programmed and dispatched from there, is this still required that they have proof of financial responsibility with the county treasurer, and which county would that be?
Sir, that in this case, Mr. Chairman, in this case, it'd be treated like any owner of any vehicle not licensed and registered in Wyoming. So if the vehicle, let's say the dispatch, it's a class 5 vehicle, and the operator is a commercial truck driver from Iowa, and they dispatch their truck on I-80 to take a load of goods from somewhere in Iowa to San Francisco, and the vehicle was involved in an incident, then the owner in Iowa would be responsible, would have the financial responsibility. Currently, if we do not require an out-of-state driver to provide proof of financial responsibility to an in-state entity right now, then this treats autonomous vehicles or automated driving system vehicles the same way.
Mr. Kirchmeyer, what I'm after is companies outside Wyoming, the vehicle is in Wyoming, and they just dispatch it anywhere in the state to say to transport disabled people. One day it's in Sheridan, the next day it's in Cheyenne, but it's an out-of-state vehicle. They're still handled the same as Any out-of-state vehicle?
Mr. Chairman, that is correct. And again, that goes with, along with the guidance we were given, treat these vehicles as much as we do non-automated driving system vehicles.
Okay, thank you. Proceed.
Sure. 3121-105, sir, I want to highlight on the bottom of page 12, paragraph C. And this gets back to the reason the data system recorder is still in definitions. Originally, this paragraph referred to having access to the data system recorder in the vehicle or event data recorder. Throughout testimony, and as we adapted this bill, Colonel Howler of the Highway Patrol testified that really what he wanted was he wanted the same access to information from a vehicle that he has currently with a driver operated vehicle. The wording we came up with is in paragraph C, line 20. ADS shall, lines 19 and 20, the information from a vehicle equipped with an ADS shall be accessible to law enforcement in relation to a crash. That used to say we have access to the event data recorder. We agreed that it was best to just, again, treat it just like, or as close as possible, as long as we could, as vehicles not with an ADS. So as long as we have access to the information, the way it's worded here, the department feels that this covers the requirement, and that therefore that definition, since the term is no longer used in the law or in the bill, that definition could safely be removed from the definitions portion.
Representative McGuire.
Thank you very much, Mr. Chairman. So the last time that we saw this, I had a serious question with this, and that is insofar as with regard to the NTSB, if an aircraft crashes and there are injuries, then the people who may be seeking compensation due to negligence have complete open access to the information up to and including the crash, whether it be mechanical or whether it be an error of the operator. And so I'm just curious, I appreciate the fact that now there is access for law enforcement, but I'm curious if that is full and open access. And I'm also curious if you could address it. What if someone in my family is injured? What if one of these autonomous vehicles is involved in an accident, kills a member of my family? Then how do I go about investigating and contemplating liability against the operator of that vehicle? Thank you.
Mr. Kirkmeyer.
Mr. Chairman, I'll attempt to answer that. From the perspective of the department, the issues brought up really would require some sort of law enforcement involvement. If there's an accident or a crash, there's going to be law enforcement involvement. Paragraph C basically points back to the Wyoming statutes that require the law enforcement entity to get a court release of information. So from our perspective and based upon the recommendation, we believe that this covers appropriately since it refers to how non-autonomous vehicles or automated driving system vehicles, that information would be gathered, that it would also cover it in the respect brought up.
Representative Baker.
Thank you, Mr. Chairman. My question revolves around criminal liability and how would we as a state or an entity hold someone accountable who is involved in criminal activity if a truck is rolling down the interstate and it has illegal, say, any sort of product or anything in it? How would we hold that entity liable?
Mr. Kirkmeyer.
Mr. Chairman, I honestly do not have a good answer for that question. We did not consider external criminal use of a vehicle in operations of the vehicle itself. And so I do not know how to answer that. I don't have an answer for you. And perhaps the director has some better background.
Director Reiner?
Yeah, Mr. Chairman, Representative Baker, I think I simply say, so a good question. I see it as outside the scope of this particular bill, but the practice that we use throughout this process was to not change the operational parameters on our roads, to treat these vehicles exactly like we treat the manned vehicles that are on the road today. So I would suspect that the registered owner of that vehicle, if it was conducting illicit activities, would be held liable.
Representative Baker, do you have a follow-up to that? No. Representative Burt?
Thank you, Mr. Chairman. Working off of Representative McGuire's question on liability, if we're going to look at the autonomous vehicle, same as we would a regular driver, if I get into an accident and I kill somebody with a commercial license, I would have to be subject to a drug and probably a drug and alcohol test. If we go the example where the driver could be in Iowa and one of these vehicles gets to an accident on Wyoming roads, how would we be able to test if the operator in another state, isn't under the influence of, alcohol or drugs? Thank you.
Mr. Kirkmeyer?
Mr. Chairman, that's a good question. It's important to remember the difference between a human driver. We specifically stayed away from the term operator because of all the baggage that came with that. In fact, that term is not used in this SAE standard. It is specific to what each individual is doing with regards to the vehicle itself. So a dispatching entity is the entity or person that launches the fully autonomous vehicle, the level 5 vehicle, on its way, pushes the go button, so to speak. From that perspective, that person does not have to be licensed because the bill says the vehicle itself is considered to be the licensed driver. However, with regards to liability, earlier on, I think it's in section 102, it says the owner, the vehicle owner in that case is responsible, or in cases where the vehicle may not have been sold, it would be the vehicle manufacturer. And I believe I can go back and read that language for you. Let's see, I think it's 3121-102. Let's see. B? No, that's for changing adding an automated system. Okay, it is in 3121-103. In paragraph A, subparagraph 2, the automated driving system is considered to be licensed to operate the vehicle if the dispatching entity has a valid class of license, again for 3 or 4. If the vehicle is equipped with level 5 as defined in the SAE-J 3016 standard, the automated driving system is considered to be licensed to operate it. So there's the licensed operator and who that is. And for anything below a vehicle of 5 automation, it is the person engaging the system. And for the level 5 automation, it's the level 5 automation itself is the licensed driver. Then when you get to insurance, the vehicle owner submits proof of financial responsibility. So the owner, in the case of a level 5 system, whoever the owner is would be liable or responsible for what the vehicle does or doesn't do. Did that answer the question, Mr. Chairman?
I think so. Representative McGuire.
Thank you, Mr. Chairman. So going along the lines of treating these autonomous vehicles the same way as we treat a vehicle that's currently on our roads. So let's say that our good highway patrol is cruising along. They have probable cause to believe that there is an issue with one of the vehicles. Maybe the back door is open and they can see something inside, hazardous materials, and they don't believe that it's properly placated on the outside. How do they stop that vehicle?
Mr. Kirkmeyer? Or
Mr. Mr. Chairman, I would have to refer again back to what the director said earlier about the scope of this bill and what it was meant to cover. And I would say that that type of event is not addressed in this bill unless the director wants to correct that.
Director?
Yeah, Mr. Chairman, Representative McGuire, I'd agree with the scope issue there. And a lot of this will follow on rules and regs. Again, remember, this is setting the legal parameters for us to allow these and to start permitting them on the road. However, what I envision is, I suspect you can program these vehicles. If there's a flashing lights in your mirrors for 10 seconds, pull over. I think the rest will come. But again, not specifically addressed in this bill.
Other questions? Mr. Kirkmeyer, proceed. I think we are maybe on page 11.
Sir, yeah, Mr. Chairman, I think we're a little bit beyond that, unless there are any more questions about 3121-105. I will highlight, though, based upon the previous question, in both paragraphs B and C, it does not only address crashes, but also violation of traffic law, but not specific to the question posed earlier. Pending any questions, I'll move on to page 13, 3121-106, on-demand autonomous vehicle network and commercial vehicles equipped with an ADS. Really nothing to highlight here. Again, I think both of these paragraphs have been changed over time to reflect the desire to treat automated driving system equipped vehicles as much as possible as non-equipped vehicles.
Okay, proceed.
Continue on, 3121-107, registration and title of vehicles equipped with ADS, top of page 13, continuing on to 14. Just want to highlight here that it was our desire here to make a recommendation that a vehicle deemed to have an automated driving system, whether it originally has it or later on it gets added, that is therefore noted on the title, because the perception is these vehicles will cost more to begin with, likely, and maintain their value better. And that's really what this puts in place. It allows us to put it on their title, registered as such, and it maintains the value for the owner.
Continue.
Pending any, are ready to continue, Mr. Chairman?
Continue, please.
We'll continue on to 3121-108, about the middle of page 15. I only want to highlight here the fact that that the federal laws will really kind of dictate some of the things that we're currently struggling with. And I will note for you that even the federal government is challenged to come up with some of the safety requirements and is still working some of that out.
Representative Henderson.
Thank you, Mr. Chairman. What kind of things are you struggling with?
Mr. Kirkmeyer?
Sir, so I'll just note an article that I saw this week, and it kind of highlights what's going on at the federal level. So they really determined the safety requirements and some of the design criteria. And right now they haven't determined that yet and published it for the industry. So we've been careful in our recommendation to you to not establish or to suggest design criteria for these vehicles. Really, because if that is changed at the federal level, then we have to go back through this and probably and fix some of it. So, or some of the safety considerations, some of that other things. And I think one of those things is to highlight is this notion of the data recorder. The data recorder disappeared from the SAE definitions in the 2018 edition. It was in an earlier edition, and it disappeared. And probably because that in future technology, a thing called an event data recorder may no longer even be in the vehicle. It may be replaced, or some other type of component or system may take its place. And so that's the type of thing that we're trying to make sure we steer away from, because even the federal rule makers haven't decided some of these things yet.
Representative Henderson.
Thank you, Mr. Chairman. I appreciate that overview. That seems to make sense. So given the recent experience I'm hearing, how much of this has actually been validated, in the real world, out and about Wyoming, in terms of railroad crossings, weather conditions and so forth?
Mr. Kirkmeyer.
Mr. Chairman, I appreciate that question because it highlights some of the challenges that we have and the industry as a whole has. So currently there really are no level 5 capable vehicles. There might be a few, and I'm talking about shuttle or taxi services. Some of you may be familiar with, there was a pharmacy, I believe, in Jacksonville, Florida, that ran medicine between hospitals with some shuttles that didn't have human drivers, and they had a very known short route. Another example is this summer, the National Park Service will test a shuttle service in Yellowstone in Wyoming. And that is a shuttle that will be programmed to drive a very specific route in a very specific area where all known and or expected obstacles could present themselves, up to and include a buffalo wandering across the trail it's driving on. But for the most part, the vehicles aren't there yet. Yes, there are some places where some vehicles have been so well programmed because the streets are so known that they can, or they have pretty much programmed in or put enough sensors on the vehicle to get it from known point A to known point B, because it doesn't change very much. But really what we're trying to do here is establish the operating paradigm for the industry. And that's what this legislation is trying to do, is kind of set the playing field in the rule book in Wyoming, because we didn't have anything. Most states do have either legislation or some type of executive order. I think we're up to 38 or 39 now. We didn't have anything. The second thing to note is the template that we used came from the Safe Driving Coalition. And then we added to that based upon the guidance we were giving. And then the Safe Driving Coalition represents the level 4 and level 5 autonomous vehicle operators and designers. So really what we're hoping is we establish the ground rules, and then from there we can address specifics in rules and regulations that the department can that are more flexible without having to come back and change the legislation as the technology advances, as it certainly will.
Okay, all right. Mr. Representative O'Hearn.
Thank you, Mr. Chairman. Are autonomous vehicles all regulated to follow all rules and regulations on the road, i.e. speed limits? Or are they going to be allowed to go with the speeds that are allowed on Denver highways?
Mr. Kirkmeyer.
Mr. Chairman, that also is a good question. And I like these questions because they're going to lead into our one main sticking point that I'm going to get to very quickly here. Right now, again, because autonomous vehicles have to have a human driver, the level 3 and level 4, the human driver is still responsible. So if the human driver engages the autonomous system, whether it's level 3 or level 4, they still have to monitor it. Generally, autonomous systems are designed not to exceed the speed limit. And the whole argument from the industry is autonomous vehicles will be safer because they won't do stupid things that people sometimes do, or they won't willingly break speed limits, or they won't do a lot of some of the things that people do. And that's a general safety argument from the industry. And I think generally you can accept that. The problem you have is when an autonomous system is faced with a decision where it has to break one or another law in order to prevent a disaster. And at that point, when you take out the human decision making, does the autonomous system make the correct decision? We're not there yet because the systems are not capable, except for in those very few instances where it is a very known, small, short range where everything's programmed. They're not capable of running by themselves. So right now, there are no level 5 autonomous vehicles driving out on the highway. Anything that's being tested is being tested and has safety drivers. There are a couple of incidences of some of the companies that are further ahead on known routes removing the safety driver. But for the most part, they're not at the point yet where the system is making the decision to speed or not speed.
Mr. Kirkmeyer, proceed.
All right, sir. The next is top of page 16, operation of a human driver, a vehicle equipped with an ADS. Basically, this gets into the level 3 and level 4 that says the human can take over for the system. The human can engage the system. If the human is in the driving position and takes over for the system, they have to be licensed to operate the vehicle. And then again, the one thing that we did get into in this was we recommended, and it stayed in the legislation, the requirement for the system. We didn't say how, but the system should notify the human driver if it's disengaged, a lot like a cruise control. We felt that was a necessary safety aspect for the person behind the wheel to know whether or not the ADS was engaged, just like currently with a cruise control. And because the federal folks haven't settled on those safety requirements yet, this is one case where we actually felt it was necessary to put in that safety caveat. Pending any questions, sir, I'll get on to probably the most contentious part, which is on page 18, section 3121-110, temporary ADS operating permits. The department originally recommended testing permits. That was changed to temporary operating permits. The industry does not like this. And again, we were directed to give holistic legislation. So where some states have entire pieces of law that just cover testing, we willed it down to one paragraph. You will note in paragraph A, first I want to line 4, where the title is temporary ADS operating permits. But on line 8, the wording was changed from permitting to notifying. So the department recommends that the wording revert back to the original wording, where a company who desires to demonstrate or test an AV that has not either been given the waiver by the federal or approved by the federal system to operate, which means that it is not currently blessed, that they have to get a testing permit and not just notify the department that they want to conduct testing. Again, this is a safety consideration from our perspective. There was concern from some of the industry folks that a permitting procedure or process would be too time consuming and that they would prefer to just notify us that they were going to conduct a demonstration or test. From our perspective, we felt it's necessary for there actually to be a testing permit for a number of reasons. The first is arguably a vehicle that's being tested has not been approved yet. Therefore, it may not be licensed or registered. So notification of an unregistered or licensed vehicle operating on Wyoming roadways was not kind of the direction we wanted to recommend. The second reason is if we make it a testing permit instead of a notification, the department has time to review what's happening and whether the testing will be safely conducted or not. The industry representatives are very comfortable with their technology and they're very used to it, but the public writ large is not. So not only do we have the ability to assess the safety aspects of it and make sure that those are in place, we have the ability to communicate the testing, when it's going to happen, where it's going to happen to the district or the area that's going to happen, and notify the public to address any concerns they might have. And then finally, the issue of us taking an inordinate amount of time to issue a permitting versus them just notifying us and then going and conducting their test. I believe we can address that concern very properly in rules and regulations. And I don't see where issuing a testing permit would take that much longer than being notified by the company that they want to conduct a test. So pending any questions on paragraph A, sir, I'd like to move to paragraph B.
Representative McGuire.
Thank you, Mr. Chairman. And I guess I would say without any reservation that I would much rather have our favorite director of our favorite department making these decisions with regard to testing. And I would refer back to page number 16, paragraph B at the top of the page. And it's kind of, I would like to tie this into the question of how we should make the amendment to 3121-110 insofar as it seems to take out any local control. It says that no state agency, political subdivision, county, municipality, or local entity may prohibit the operation of. And it seems to me, especially with regard to testing, if you've got some small communities that may have special events in the summertime or whatever, that they should have a place at the table if these autonomous vehicles are going to be rolling through their town. I can think of one that I go through almost every day in the summertime that has rodeos and everything else and sheep and cattle going down the main street. Seems to me like they should have a place at the table. So I'm curious if there's an amendment proposed for 3121-110 that puts the department back in charge, which I think that they certainly should be. Should it also add to that the ability for the municipality or subdivision, which is in charge of the highway or that road and the safety of its citizens, to be involved in that decision also? Thank you.
Mr. Kirkmeyer.
Mr. Chairman, it's important to understand paragraph 3121-1010 and its purpose, and then the rest of the legislation. So the rest of the legislation really is pointed at safe operation and integration of vehicles that have gone through their design and testing, that have been approved by the federal agencies. They either have their waiver or they have their certification. So with respect to the paragraph brought up about at top of page was 16, except it provided in a subsection of this section, no state agency, political subdivision. That is in the case where a fully autonomous vehicle that has been licensed, has been certified, is capable of operating within its operational design domain anywhere, and is operating. The intent there is to prevent, another sub entity for saying, well, but you can operate anywhere in the state, but not here in my area. So that is that is the intent of that paragraph, is the vehicles have been tested, they're fully developed, they're licensed, they're operating all over the place. It would be paramount to maybe saying, you can't drive your station wagon on Main Street in Laramie because I don't like station wagons or whatever. It's to prevent that type of thing. Now, getting to the second part of the question, and really the notion of and why we think temporary permits are important is because they're to address testing and demonstrations. And I think that gets more to the question here is we are putting or considering putting a vehicle or testing a vehicle to expand its operational driving domain or to make sure it can handle obstacles. And then that's where we think the department recommends we get that opportunity to review the testing parameters, to review the safety parameters, to see where it's going to be in the state, to have time to talk, if necessary, to local officials or local law enforcement to make sure that the public is comfortable with it, which is why we recommended this be a testing or temporary operating permit and not a notification procedure to begin with, which also highlights the fact that right now, as this paragraph is written, where it says notify on line 8, but it says temporary operating permits on line 4, it is unclear on whether it's an actual temporary operating permit or a notification. So we recommend it be a temporary operating permit to address, I hope, the concerns I heard issued in the question.
Other questions? Okay, Mr. Kirkmeyer, proceed, please.
Next, Mr. Chairman, is paragraph B. This was an addition by the insurance industry. All I will note for the committee here is the industry really hasn't pushed back since this got moved to the temporary operating permit paragraph. And really what this is for vehicles that are going to be tested or demonstrated, the company that is the manufacturer has got to provide $5 million liability proof. It requires the department to collect this information. We don't have an opinion one way or another, other than to highlight that we currently do not collect any liability insurance data from a manufacturer. And so this would require an additional administrative procedure and administrative conduct from the department side, since we do not do this right now. And that's all I want to highlight for you. Unless the director wants to add something.
Director? Nope.
All right, sir. Final section. I'm sorry.
Continue.
No comments.
Paragraph section 3121-111, starting at the top of page 18 and then continuing on through 19 and 20. Sir, really nothing here to highlight. This just develops that, this directs that we set up the account that allows us to collect funds that we might have to collect in order to cover our costs to conduct testing and demonstrations. We have really nothing to highlight on this or any of the rest of the bill. Pending any questions, sir, that's all I have.
Any additional questions? Okay. Anyone? So, Mr. Kirkmeyer, as we go through this bill, I had a few, and probably have to propose a few amendments. One is on page 7 where we talk about SEA standard 3016, and it says any successor standard publications. I've been told by the Attorney General we don't put that into statute because we're committing the legislature and the state to something that doesn't even exist yet. So that would be one. The other one is I'm on page 8 at the bottom, paragraph 4. How do you address the issue of line 20 says safety standards under 31.5.901 through 970, unless a waiver has been granted by the relevant regulating agency. I didn't think agencies could grant waivers to state statute.
Sir, for your first question, the SAE J3016, a part of that statement that you are referring to, I don't recall exactly how that second part of the sentence got put in. I don't think the department recommended that portion. I think that got added later, and I can go back in my records. The point that what I think they were after here, though, is these, like I said, these SAE standards for this technology change about every 2 years. Definitions change, some definitions drop off, some get added in. And I think the intent here was if the definition for, say, operation or dynamic driving task changed, then this statute would adjust its definition accordingly. But I can't say that that is exactly what it was after. I'm just noting that this is a dynamic technology and what these terms mean change frequently. And I think it was just an attempt to, so every 2 years we weren't coming in and changing the definitions in the bill. For your second issue, sir, so that was really meant to address the federal government currently issuing waivers for some of these vehicles for specific items. And that's why it says relevant regulating agency. The federal government can issue operational waivers for design criteria on vehicles. And if they issued a waiver, then we would accept that as we currently do. Pending any corrections or additions from the director, I'll stop there.
All right. Other questions? Questions for Mr. Kirkmeyer? Okay. So, Amanda, how many people do we have in the waiting room who may wish to speak on this?
Currently, just have one with their hand raised. If anyone else would like to speak, can you ask them to raise their hand, Mr.
Yes,
Chairman?
if anyone who would like to speak could raise your hand so I get an idea of how many people.
Still looking like just one, Mr. Chairman.
All right. Okay, so with that, I'll open up public comment. Anybody in the audience wish to comment in the room? Okay, no one in the room? Oh, Ms. Wilkinson, please come forward. I'm going to alternate between the room and the virtual attendees.
Thank you, Mr. Chairman. Members of the committee, my name is Catherine Wilkinson. I'm here today on behalf of American Property and Casualty Insurance Association. Here in support of the bill, although we do have a few concerns with it that I would like to point out to you. We did prefer that 5 million liability insurance that you did hear about that was removed from the Senate on page 16. APCIA does believe that the system manufacturers should maintain a 5 million liability insurance at all times, not just during the testing phase. So there was an amendment on the Senate that did move it to testing only on page 18 in lines 12 through 19. And we would request that you consider moving that language back to page 16, deleting the first two lines and then starting with the manufacturer. So we do believe that that 5 million liability policy should carry forward with the manufacturers at all times. The other bit of information, I believe you'll have another amendment presented on the data recorders with regard to access of retrieval of information should there be a crash. APCIA does believe that all of these vehicles should have a data recorder, or there's another acronym that I am spacing out on the name of it, but the vehicle should maintain those. So we would stand in support of that amendment when it is presented. And with that, Mr. Chairman, I would stand for any questions you may have.
Any questions for Ms. Wilkinson? Thank you, Ms. Wilkinson.
Thank you.
Who is it we have on the virtual.
Mr. Chairman, we have Mr. Josh Fisher.
Mr. Fisher, proceed, please.
Mr. Chairman, thank you. And members of the committee, my name's Josh Fisher, and I'm here with the Alliance for Automotive Innovation. We represent the vehicle manufacturers that produce nearly 99% of all the light-duty cars and trucks sold in the United States. We also represent several AV developers, including Cruise and companies like Argo that you may have heard of, who are developing AV technology as well. So I want to thank the committee again for the opportunity to speak today. And we've been engaged in this process from last fall, from the beginning, with Jesse and the folks at YDOT and the other stakeholders. And we want to thank them for their collaboration and thoughtful approach to this issue. And we think the bill is in pretty good shape right now. There are some issues that I would like to address today. And with your permission, Mr. Chairman, I'd like to go through those right now. We have some suggested amendments I'd like to walk through.
Please proceed.
Thank you, Mr. Chairman. The first would be on page 2, lines 9 through 16. Mr. Kirkmeyer brought this up. It's the definition of automated driving system. Data recorder, our suggested amendment would be to strike that term entirely. And if there, that's pretty straightforward. If there's no questions, I can keep it moving here.
Representative McGuire.
Thank you, Mr. Chairman. So why would we want to strike that when data recorders were first installed in aircraft? They were analog. They actually had a needle that looked like a vinyl record, and they have proceeded up to where now they're solid state. And it's just a term of art, and it's a device that is used to record the relevant data so that the NTSB and other entities who are investigating an accident have actual real-time data prior to and up through the accident. Why in the world would we want to delete that from a vehicle which is going to be rolling along at a very heavy weight on busy highways? Why in the world would we not want to have that data if there's an accident? Please explain that.
Mr. Fisher?
Mr. Chairman, Representative McGuire, our requested amendment here is to strike the definition as it's not applied anywhere in the bill. It's not related to the actual event data recorder or anything like that. It's just because, as Mr. Kirchmeyer explained, that definition was a holdover from previous drafts. And as the term's not applied anymore, we don't see the need for the definition in this bill right now.
Okay. Other questions? Representative O'Hearn.
Thank you, Mr. Chairman. Will every autonomous vehicle have an events data recorder? So we have that data?
Mr. Fisher?
The expectation is that there will be some device. It may have a different term in the future, but there's a lot of information produced by vehicles now, and there's going to be some device, most likely, that will be able to track that information. So the idea is not to hide the data from anybody here. It's, one, the term is not applied in the bill, so we want to strike it. And two, when you look further down the road, nearly every vehicle produced today has some sort of event data recorder in it right now. So the expectation is moving into the future that there will be some device similar, if not the same. Yes.
Questions? Okay. Mr. Fisher, please proceed.
Thank you, Mr. Chairman. The second amendment would be on page 8, lines 5 through 9. And this goes to the railroad language. And we have shared our suggested amendments with the railroads, and I don't want to speak for them. I understand that they may be in the room and will be able to speak for themselves, but my understanding is that in our conversations with Union Pacific that they have agreed to this, but again, I'll let them speak for themselves if they are in the room. But our suggested amendment would be on page 8, starting on line 8, after state, comma, and we would want to insert the following, quote, including safely negotiating railroad crossings, comma, end quote. So this would require that if a rail crossing is in the operational design domain of a vehicle, that the vehicle would have to be able to safely negotiate that crossing. However, as Mr. Kirchmeier explained, there could be instances where the vehicle would never encounter a rail crossing, but the language as it currently exists in the bill would dictate that even if the vehicle is not going to encounter a rail crossing, it would still have to be able to safely encounter it within its operational design domain. So that doesn't make sense to us. We want the vehicles, if they're going to encounter a rail crossing, to be able to safely do that. And we think that our suggested amendment accomplishes that goal.
Okay, proceed unless there are questions. Nope, no questions.
Okay, so the next amendment would be the follow-up to this, and that it would be on page 9, lines 1 through 12, and it would strike the existing language on rail crossings as it exists in the bill now.
Okay.
Any
Questions? Okay. Mr. Fisher, would you repeat the lines, please, the line numbers?
Sure, page 9, lines 1 through 12.
Okay. Thank you. Proceed.
Thank you, Mr. Chairman.
One moment.
Sure.
Representative Obermuller.
Thank you, Mr. Chairman. Maybe this is already covered too in this sheet, but just going back to page 8, line 8 on page 8. Where you have the insert including safety negotiation railroad crossings, and then that sentence on line 8 ends with unless an exemption has been granted. And I say you're deleting that language on page 9. Is your intent to also delete that language and on page 8, line 8?
Mr. Chairman, Representative, no, that was left in there. Let me back up here. We deleted that language on page 9 because we're striking that entire section because we believe that the language we're inserting here captures the same intent for the vehicle to be able to safely negotiate a rail crossing. We didn't really understand what exemptions may be granted, so we didn't want to touch that. We didn't know if that was a YDOT issue. But from our perspective, it was something that YDOT or the committee could address. But it's not our intent to strike it here, but we're not opposed or for it one way or the other.
Thank you.
Okay. All right. Mr. Fisher, proceed, please.
Thank you, Mr. Chairman. And then moving to page 12, at the bottom of the page, lines 19 through 22, continued on to page 13, lines 1 through 2. We would propose striking subsection C in its entirety. This section, as Mr. Kirchmeier explained, deals with crash reporting and information from the vehicles. So this section would require that following a crash or violation in automated vehicles, information be accessible by law enforcement if that same information could be obtained from a human driver of a conventional vehicle. Now, section A under 3112-105 already requires that the vehicle owner or person acting on behalf of the owner must report the crash and provide information required by law. So from our point of view, sub C is already taken care of by subsection A above it. And we're not really sure what additional information would be gleaned under subsection C that would not already be required under existing law or under subsection A of this bill. So, as we've discussed, event data recorder information, that's owned by the vehicle owner, according to the Driver Privacy Act. So there are some issues involved of just not handing the information over to law enforcement. It's the owner's responsibility to work with law enforcement as part of an investigation. Law enforcement has tools that they use now, including warrants, to obtain that information if the vehicle owner is not forthcoming and is needed as part of an investigation. And we believe those same rules and processes would apply to automated vehicles moving forward. So our critique again with subsection C is that we think current law and the provisions up above in subsection A already envision the world of information and the processes that are needed to obtain that information, and would again suggest that subsection C be struck from the bill.
Thank you, Mr. Chairman. I believe that would be the Fifth Amendment, the right against self-incrimination. I'm just curious, does a robot driver of a Class 8 vehicle somehow have a Fifth Amendment right to protect data and not produce that information if there's an investigation? I just don't understand why there would be any kind of a barrier to gaining that information.
Mr. Fisher, just one moment before you respond for the people on the audience and listening on the virtual. We will go till 2:30. We've recessed until 2:30. So if you're looking at your watch wondering what we're going to do at 2 o'clock, we'll continue. So we won't be going back into session till 2:30. Mr. Fisher, if you could answer the question, please.
Sure. Mr. Chairman, Representative McGuire, if the vehicle is owned by a company, the company does have similar interest in data ownership. So again, it's not about not providing the data. It's about using the tools that currently exist that would apply the same to automated vehicles. We also believe that automated vehicles should be treated as similar or the same as conventional vehicles. And if the tools currently exist to obtain the information following a crash, we don't see the need to create new tools if they're not needed. Again, it's about working with law enforcement. And if there is a dispute about some of the information, again, there are processes where law enforcement can seek a warrant to obtain that information if required, same as they do right now with human drivers.
All right, Mr. Fisher, proceed if you would, please.
Those are all of our suggested amendments, Mr. Chairman. I would like to address the comments from the representative from APCIA, if I may, just because we do disagree with their request to insert the language on the data logger. Again, this is, in our opinion, a vehicle design requirement. As I mentioned earlier, the expectation is that these devices will be in vehicles moving forward, as they currently are in vehicles now in the market. But we don't believe states should be dictating how a vehicle should be designed. If Wyoming were to dictate one requirement and Utah another and South Dakota another, well, you can get the picture very quickly that we would have to make vehicles for 50 different markets instead of making one vehicle for one US market. We would be forced to make 50 vehicles for 50 different markets within the US, and that is impractical from our point of view. And again, we would oppose the addition of the data logger language as requested by APCIA.
Okay, any questions, other questions for Mr. Fisher? Okay, thank you, Mr. Fisher. Who else here in the audience? Please, come on up.
Mr. Chairman, members of the committee, good afternoon. My name is Erin Taylor. I'm here representing the Union Pacific. And I just wanted to follow up on the comments that you heard from Mr. Fisher. We have worked together and also with the Burlington Northern Santa Fe to come to the language that's been presented for you today. So I just wanted to let you know that we support this. As you heard from the director, the point of this bill and for the point of the railroads is to make sure that ADS vehicles operate and are subject to the same safety rules of the road that human drivers have today. And so the language that was agreed to, I think, is something that we can all get behind, and it is in other states.
Any questions for Ms. Taylor? Questions? Thank you, Ms. Taylor.
Thank you.
Ms.
Good
Shaner,
afternoon,
please.
Mr. Chairman, members of the committee. My name is Mary Ann Shaner, and I am here today representing State Farm Insurance. And the issue that we would like to address today relates to the data recorder. And a data recorder in a vehicle is absolutely essential. It's essential for insurance purposes. It's essential for determining how a crash occurred. Data access from the insurance perspective is important for proper pricing and underwriting of vehicles. It's critical for liability determinations. And from the general public's perspective, it's important in determining the safety and reliability of technology. So on the Senate side, what State Farm proposed is that we make the data recorder mandatory in these vehicles. And there's pushback because I say it's a federal standard, Wyoming state shouldn't get involved. You can have differing standards. Well, the state of California, although we typically don't, rely on them often in Wyoming for regulations, has required that the manufacturer certify that a data recorder is in these vehicles. And I understand that the technology may change, but the laws can change as well as that technology develops. And I think that it's very concerning, particularly with autonomous vehicles, where you potentially have a vehicle that doesn't have a driver. So you can't go up to the driver and say, oh, what happened? They could say, oh, I hit my brakes. I saw this. This is what happened. It's the vehicle. So the data is absolutely critical in these vehicles for law enforcement to have access to. So we are adamantly opposed to having the deletion of data recorder on page 2, as proposed by the department, as well as proposed by the manufacturer. We think that definition should be maintained within the bill. And to address the concern that it isn't used in the bill, I have presented to you an amendment on page 12, line 20, that would include that the information from a vehicle equipped with an ADS, including information from the ADS data recorder. And this section was also just proposed to be deleted. Again, we think the data from these vehicles is absolutely essential for law enforcement, as well as for others in determination of liability for in the event that there is an accident.
Question, Representative Henderson?
Thank you, Mr. Chairman. I tend to agree with you. My question has to do with those situations where, you have the human and you have the automated device. And how do we make sure that we don't have one pointing at the other in terms of circumstances and events? And it seems to me the recorder is one source of information. So the follow-up to that is, would there be any potential for disclosure of proprietary information in the use or access to that information?
Ms. Shaner?
Mr. Chairman, Representative Henderson, I believe that there are tools out there that are standard for access to this type of information that protects the proprietary nature. And certainly that's a concern, but I believe that it is addressed. But I can provide additional follow-up to you on that as well. Mr. Chairman, and so I would say that, I would recommend that the committee maintain the definition of a data recorder and that we use it within the bill. And like I said, I proposed an amendment to you that was just handed out that would make it so that it would include that the information within the data recorder would be accessible to law enforcement. The other option is to make it mandatory that these vehicles have an ADS recorder. And we would propose, if you would like to go that direction, I could email some language, but it would be, give me just one second. On page, excuse me, believe that it would be adding to 3121-102A that the vehicle meets all of the following conditions, and that you would add in a condition in there that the vehicle is equipped with an ADS data recorder, and the data captured and stored by the ADS data recorder in a read-only format must be capable of being accessed and retrieved by a commercially available tool. So that would be adding a new subsection under A. So I think it would end up being VI would be on page 9 to add that language if you wanted to make it mandatory.
Questions for Ms. Shaner? Thank you. Thank you, Ms. Shaner.
Thank you.
Anyone else in the audience wish to speak on this bill? Anyone else? Amanda, is anyone else in the waiting room?
Mr. Chairman, no one has their hand raised at the moment.
Okay, Representative McGuire.
Thank you, Mr. Chairman. I have a question for the director of our department, which keeps our highways clear and safe. And Director, are you there? Thank you, Director.
Chairman, Representative McGuire, yes, sir.
All right, so the information that I've been reading is talking about running Class 8s, I call them Class 8s, heavy trucks across I-80. And they're talking about the vehicles that they'll be building to do this, running a hybrid form of fuel, whether it be compressed natural gas plus electric or some combination thereof, and that they would be going from major terminal to major terminal. So for example, Salt Lake to maybe Cheyenne, Salt Lake to Utah, or Salt Lake to Omaha. And obviously these vehicles would not stop anywhere. They would not be buying diesel fuel. They wouldn't be buying chicken fried steak anywhere. I'm just curious, there's going to be a lot of wear and tear on I-80, which is already in desperate need of repair. How is the state of Wyoming going to be compensated for all the wear and tear of these heavy vehicles running across I-80 if they're not buying any fuel or anything else when they're going across our highway? Thank you, Mr. Director.
Director?
Mr. Chairman, Representative McGuire, a most excellent question, and I think something that we need to discuss over time. Obviously, part of the discussion we had last interim was some sort of road usage charge. Obviously, tolling is in the works for the road you indicated, I-80. But Mr. Chairman and Representative McGuire, that is certainly, outside the scope of this bill, but it is of concern to us as we look at funding our roads.
Thank you, Director. Okay. So no one else wishing to speak, I'll close public testimony. Committee? Moved by O'Hearn. Seconded by Obermueller. So committee, go through the bill. So, and there have been a lot of amendments proposed. And so if you wish to move any of those, I'm going to ask you to be very specific so that Diana can take these down and that she has all the information we need. So with that, I'll go to page 1. Page 2. Okay. Any amendments? Page 3. Okay, well, I'll propose one on back to page 2 then. Amendment to delete paragraph A sub I, so that would be to delete lines 9 through 16.
Second.
Okay, seconded by Brown. Any discussion? Representative Henderson.
Thank you, Mr. Chairman. I would just gently and carefully push back on that. I mean, there is some difference of opinion or perspective, I suppose, but if we're going to add the amendment that's just been recently suggested later, then the committee may wish to give this some thought and perhaps look at it on the floor.
Okay. Representative McGuire.
Thank you, Mr. Chairman. I would push back also insofar as I think it's a vital piece of information. I think it's information that should be available not only to law enforcement, but also to individuals that may be injured. How often do we read about a bad accident on I-80 where people are severely injured or killed? And those families have a right to find out what's going on. So I think that the data should be there. And whether or not it's in this bill, it can always be included by the department in rules and regs. So I would push back, and I would hope that the committee would see fit to keep that as stated in the bill. Thank you, Mr. Chairman.
Any other comments? Representative O'Hearn.
Thank you, Mr. Chairman. I agree. We need to leave this here or an event data recorder like I asked. And I was going to make that amendment on page 9.
Okay. We'll get there in a minute. No other comments? All in favor, say aye. Aye. All opposed?
No.
Okay, amendment fails. Page 3. Okay, page 4. Okay, I would propose one then on page 4, more of a question, and I guess I'll move the amendment and then we can discuss it on line 14. I don't understand how a autonomous vehicle or automated driving system can gesture. I imagine we could put it in there somehow, but so that would be my amendment, would be after is to delete and gesturing and put a period after signaling.
Second.
Second. Okay, any discussion?
Question.
Question being called. All in favor of that amendment, please say aye.
Aye.
Okay. Hold on, I need to make sure my notes are accurate. Diana, do you have that one? Thank you. Okay. Representative Henderson.
Just a quick question. Thank you, Mr. Chairman. So we have lateral and longitudinal, as you can see there on page 3 and page 4. And I think we're all aware that there's some vertical types of automated devices coming as well. And while the gentleman indicated we don't have the level 5, I just wanted to mention that there's a possibility. I mean, I came to the Capitol the other day and there was a drone flying over the street. So I don't know if we want to put it in here, but I just want to mention it for the record.
Representative, I think we're dealing mostly with highways and trucks and wheeled vehicles, surface vehicles.
Well, they don't take off, right?
Correct. Okay. Page 5. Page 6. Page 7. Okay, then I would propose an amendment that, based on my understanding on previous bills and matters with the Attorney General, that on line 10 after 2018, we place a period and strike the rest of line 18 and all of line 11. Okay.
Question.
Okay, question being called. All in favor, say aye.
Aye.
All opposed? Okay, amendment is adopted. Diana, do you have that one?
A period after 2018 and then strike the rest of the sentence.
Correct.
Okay.
Okay, line 8. Okay, any proposed amendments? Representative Henderson.
Thank you, Mr. Chairman. I'd move on page 8, line 8, after the word state, after the comma, you have state, comma, and then add the words, including safely negotiating rail crossings, comma, and then continue on.
Okay. Second, any discussion on that amendment?
Question.
Okay, I want to make sure just a moment that Diana has that. Okay, Diana, do you have that?
Yes. Do you want the quotation marks around that?
No,
No, I don't think so.
Okay.
just a comma.
Hang on, please. I need to make sure I have the correct wording. Okay, Representative Henderson, would you repeat that wording, please?
Yes.
So after state, comma,
Uh-huh.
repeat the wording, please.
Including safely negotiating railroad crossings, comma.
Okay. Is there a second? Okay, seconded by O'Hearn. Any discussion? Okay, question being called. All in favor, say aye. Aye. Opposed? Okay. Anything else on page 8? Representative McGuire.
Thank you, Mr. Chairman. Going to the bottom of the page. And so this would be paragraph Romanet 4 on line number 22. So the line, so it would read, unless a waiver has been granted by the relevant regulating agency, and I would add, and the department. The department is defined earlier as the Wyoming Department of Transportation. And the reason that I would offer this is, as the least populated state of the union, we have the least amount of political clout, and there are things that may be good in other parts of the country. Maybe they revise their rules so that these vehicles don't have to operate in a 60-mile-an-hour crosswind. But that's something that we have here regularly. So my fear is that nationally, there may be a change in the regulation, but it may not be something that's good for Wyoming and vehicles that are operated in Wyoming. So I would propose that specifically the Wyoming Department of Transportation should have final authority to grant a waiver or decline to grant that waiver. Thank you, Mr. Chairman.
Sir, seconded by Obermuller. Okay, any discussion? All in favor, say aye.
Aye.
Opposed, no. Okay, amendment is adopted.
Do you want that to just say, and the department with a capital D, or do you want it to say Y dot?
Diana, that would be to read after agency, insert and the department with a small d, and leave the semicolon where it is. So it'll be ahead of the semicolon, between the semicolon and agency.
Okay.
Page 9,
Mr. Chairman,
Representative O'Hearn.
on page 9, B, after ADS in line 18, put DR, mentioning data recorder, or EDR, event data recorder.
Okay, hold on. Where are you again, please?
On page 9, line 18.
Okay,
By installing an ADS, somebody is making their vehicle now ADS. They've changed the design of the vehicle. They've modified the vehicle with an ADS. If they have done that, I want it to have an EDR, an event data recorder in it. Or since we didn't strike out line number 1, an automated driving system data recorder. Does that make sense?
yes, but you're going to have to give us the exact wording you wish right there on line 18.
On line 18, by installing an ADS-DR or event data recorder to convert it to, after the vehicle is originally manufactured, to certify that the vehicle is equipped with an ADS, meet the conditions in subsection A of this section. So again, we need a data recorder system in that vehicle.
Okay. All right, discussion. And Representative O'Hearn, I will get with you when we're done and get the exact wording. I'm not sure I have it. I have the concept. Okay. Okay, Representative Henderson. Okay. All in favor, say aye.
Aye.
Opposed, no. Okay, amendment is adopted. Diana, Representative O'Hearn and I will get with you after the meeting and make sure we have the wording correct. Okay. On page 9, any other amendments? Okay. I would propose an amendment to strike paragraph Romanet 5. That's the one on the railroad crossings, and I believe we've already addressed that issue with the wording proposed. Second, any discussion? Okay, all in favor, say aye.
Aye.
Opposed, no. Amendment is adopted. Diana, do you have that one? That is on page 9, to delete line 1 through 12 completely. Okay. Page 10. Representative McGuire.
Thank you, Mr. Chairman. On page 10, starting on line number 9, Romanet 2, it would read, the automated driving system is considered to be licensed to operate the vehicle if the dispatching entity has a valid class of license for the type of motor vehicle being operated, if the vehicle is equipped with a level 3, and this is where the change would come in.
Okay.
So it'd be 3, 4, or 5 automation, as the standards of driving automation are defined in SAEJ 3016 standard, period. The rest of the paragraph would be stricken. The reason for offering this amendment is to say that once a vehicle goes to the 5th level of automation, that the person behind the keyboard, wherever they may be, whatever country they may be, whatever time zone they may be, doesn't have to have any training with regard to safety or what they're carrying or the rules of the road in Wyoming. To me, seems ludicrous. We hold our drivers to a very high standard here in this state. Not only if there's an accident to notify law enforcement what they've got in the back, if there's a fire, I mean, there's just a multitude of things. And to say that you can have someone with no training at all running this truck from behind a keyboard, that to me seems beyond ludicrous. So I would offer that amendment. Thank you.
Seconded by Stiver. Discussion? Question being called. All in favor, say aye.
Aye.
All opposed, no. No. Okay, that amendment has been adopted. Forgive me if I go a little slow here. I need to make sure we have all of these captured. Page 11. Page 12. Page 13.
I'll take a shot at 12 if you.
Representative McGuire.
Thank you, Mr. Chairman. I would offer the proposed amendment for page 12, line 20, beginning with paragraph C. The information from vehicle equipped with ADS, including information from the ADS data recorder, shall be accessible to law enforcement. And I would add, and all persons involved with relation to a crash, traffic information, or any other circumstance, et cetera, as it's proposed. And the reason that I would add all persons is for 2 reasons. First of all, persons has been defined to be both an individual as well as an entity. So for example, if I have an LLC, that can be a person. But certainly, if there's an accident, just as it was alluded to by the individual who was proposed the amendment, I can go and ask that person what happened. And if there's a court case, they can get on the stand and I can ask them what happened. And we can get some answers. We need, if there's an accident, and again, I would say if it's a member of your family and you want to know what's going on, we all need access to that information. And I would submit to you that there is no 5th Amendment protection against self-incrimination for a robot driver. So I would encourage the committee to adopt that amendment as proposed. Thank you.
Seconded by Stiver. Discussion? All in favor? Aye.
Aye.
All opposed, no. Okay, amendment is adopted. Okay, page 13. Representative Obermuller.
Thank you, Mr. Chairman. This is kind of follow-up with Representative Anderson. There was another piece of an amendment proposed from on page 12, line 20, where we added the information from a vehicle equipped with ADS. That amendment that was presented to us.
Representative Obermuller, that's what we just
did that.
accepted. Adopted,
Okay.
yes.
All right. Thank you.
Okay, page 13, page 14, page 15, Page 16, Representative McGuire.
Thank you, Mr. Chairman. I would propose that we reinsert the $5 million back into, and I honestly, we're moving so fast, I'd ask for your help as to where that should be. It's 7 or 8, but I'm not sure exactly where it should be resubmitted. Thank you.
Okay, so is that a conceptual amendment?
Unless you know where to put it. And I didn't mean that in a funny way. I meant to.
Yeah, I can take that several ways. Give me one moment.
Mr. Chairman, that's the one Catherine Wilkinson brought forward.
Yes, Representative O'Hearn. Ms. Wilkinson, can you tell us where you were proposing to put that?
Subsection D. And then if you take the language that's on page 18, you would strike line 11, or excuse me, line 12 up and line 13 up to the, put a period, and then start, that language would then be inserted, there'd be a capital the, and then the rest of the lines, starting with the from 13 to 19 would be the language. That would then be a new subsection D on page 16, line 14.
That's what I would propose, Mr. Chairman.
Mr. Chairman, I've got the subsection D right here.
Okay. Any, is there a second on it?
Mr. Chairman.
Yes.
Ms. Wilkinson, are you looking at just replacing the subsection D that came from the introduced to the engrossed copy that was deleted, the entire paragraph?
Mr. Chairman, that's correct.
Just reinsert that paragraph. Okay.
Yes.
Is that Mr. Representative McGuire, is that your amendment?
Mr. Chairman.
Okay.
Second.
Seconded. Any discussion?
Question.
All in favor? Aye.
Aye.
All opposed? No. Okay.
Page 16, lines 2 through 9.
Okay.
There you go. That's the original bill.
Right. Okay. Page 17, page 18, page 19. Representative Obermuller.
On page 18, there was a recommendation. I just wanted to talk about it here. There's some recommended language to incorporate operating permits into the language of A on line 6, that section there, to clarify some confusion. That rather than notification, I believe it was on line 8, that rather than notification, it was to obtain an operating permit. Maybe somebody could help me, or the person that brought that to our attention could help. I know there was a question about that.
I believe that was
Yeah.
Mr.
Chairman, that was Mr. Kirkmeyer suggesting we strike notifying.
Chairman, or I'm sorry, Director Reiner, you or Mr. Kirchmeyer, do you have language you would propose? You're muted.
Mr. Chairman, Representative Obermiller, thank you for the question. Our recommendation would be go back to the original language from the original bill. So it would be, it would require a permit versus requiring the notification. But if you go back to the original bill, it starts on the top of page 18 of the original bill and goes from line 1 to line 9. And it reads, the department may develop procedures and issue temporary operating permits for demonstration.
Okay. So is that your amendment, Representative Obermuller?
Yes, Mr. Chairman, that's my amendment.
Is there a second? Seconded by O'Hearn. Discussion? Okay. All in favor? Aye. Opposed, no. Okay, Diana, that came from the original bill. I will get with you when we're done on a number of these. Okay,
And for the record, Chairman, that'd be page 18 of the original bill.
page 18 of the original bill, line 1 through 9. If you want to make a note of that, Diana. Okay, page 19, page 20, Page 21. Okay. Discussion on the bill. Representative Henderson.
Thank you, Mr. Chairman. Just want to note at the bottom of page 19 where it's talking about annually increasing the fees subject to an index. I'd like to take a closer look at that if it goes to the floor. That's all I want to mention. Annually is troubling to me unless there's some basis for it. So it could go up, it could go down.
Okay. Just remember for all the committee, we need to be probably a little closer to the mic. The people on the
I'm sorry.
That's okay. The virtual meeting need to be able to hear us.
Okay.
So any other discussion on the bill? Okay, sensing you're ready to vote. Diana, would you take the roll, please?
Representative Baker,
No.
Representative Brown,
No.
Representative Burt,
Aye.
Representative Henderson,
Aye.
Representative McGuire,
No.
Representative Obermuller, Representative O'Hearn,
Aye.
Representative Stivar,
No.
Chairman Burkhart.
Aye. Okay, thank you. For all the people in the audience, I apologize that we did not get to Senate File 4. We'll probably hear that starting on Thursday. Thank you for your patience. This took a little longer than we thought. Okay, and with that, we are adjourned. Diana, I will get with you. Amanda, you can close the YouTube.